Good morning and welcome to today's podcast where we take complex financial topics and break them down into bite-sized pieces. My name is Carl Weiss and I am a residential loan officer with Fairway Independent Mortgage Corporation. My NMLS number is 263293. I'm licensed in 21 states, and what we're discussing here today specifically applies to our friends, family, and clients who reside in the state of Arizona. Patrick and my discussion today is general in nature. Of course, we're not giving any specific tax, legal, or mortgage advice. If you do have specific questions on how something might relate to you in your own situation, please, of course, reach out directly to either Patrick or myself so that we can give you specific advice. Today, we are joined by my good friend Patrick Macqueen from Medalist Legal. Thank you so much for joining me again, Patrick. I really appreciate it. I'm looking forward to today's discussion because this is one that really just applies to so many people, including every purchase and potentially every refinance of every home loan that we have out there. And it's an opportunity to sort of readdress this idea of who actually, owns the property that, in my case, that, we're lending against, right? So today, what we're talking about, of course, is the, how we're going to take title to property. And of course, our discussion specifically applies to those folks that are, controlling property or talking about ownership of property in Arizona. But I think it's safe to say that the concept applies to people in every state, even if that state has ways in which they differ on titling properties. So if you live in or you're buying a property in another state, please check with Patrick to get specific advice on how you may want to hold title in other states. But welcome, Patrick. How you doing today?
I'm great. And your introduction was perfect because it sort of got me thinking of ways that I've seen people goof up taking title and how that can actually have generations of effect, essentially. So
Right.
as a real estate attorney, we've seen goof ups by grandma in the 1960s that have come back to bite and haunt generations to come down the road because she did something incorrect with title or something that wasn't permitted at the time or what have you. So it applies in so many different ways, including the loan context, including the purchase context. It is just such an imperative or an important thing that you get this right, or you get what you want as soon as you can. Now you can always correct title until you can't, meaning
Right.
there's death or divorce or something like that. But you can always change it, but just know you got to change it soon if you're going to change it.
Right. And I think, one of the things that we really want to kind of jump in today is, in Arizona specifically, because we're not traditionally an attorney state. The guidance to borrowers is really very lightly handed off, and that's typically handed off by either a realtor or more likely a title company that sort of throws a sheet with a bunch of lines that they can check mark. And I think it's really important that we go through those so that people have an understanding of what are the differences. Why would I pick one over another in ways to hold the title? Because it may not seem like it matters today, but like in your example, for grandma, it certainly could have ramifications down the line, right?
100%. And I actually have my own cheat sheet that I've made. So ways to take title in Arizona. And this is a little bit more of a comprehensive look as to what you might expect in taking title in various ways. And anybody who wants a copy of that worksheet there is more than welcome to ask. But yeah, I mean, we've got some nuanced title issues here in Arizona that need to be accounted for. There's potential tax ramifications. There's potential ramifications upon death, upon divorce, to even be able to get a mortgage, that sort of stuff. And so the title stuff is incredibly important.
Well, great. Well, let's kind of jump right into, the different methods and styles of taking title and what they mean, and then maybe you can help guide us through the maze a little bit in terms of, if you've made potentially a mistake, or if your circumstances have changed and you feel like, you need to change these. People obviously can reach out to you at, I'm sure via the website at medalistlegal.com, but maybe we just start kind of on your sheet and just sort of go down the list and help educate people as to how they could take title and then maybe why they should or shouldn't.
Sure. So let's start. Let's jump right in. So
Okay.
first things first, Arizona is a community property state. So that comes with a couple of unique presumptions, legal presumptions, and it also includes a way in which you can take title, or a way in which married couples in Arizona can take title. So the first way in which a married couple, you have to be married, and it doesn't matter if you're married in Arizona or a different state. But the first way is via community property. So I convey my property, or I receive property with a community property interest only. Okay. And that's kind of a unique set of circumstances. It basically means that the married couple owns the property as a pot. It's sort of, this is ours. This is what we have. Everything that we own together goes in this community pot. Okay. The interesting thing about a pure community property designation on title is that if you are a married couple and you have this designation, each individual spouse can convey their interest to someone else upon their death. And so let's say that you have a couple that's been remarried, and they have a blended family of children from prior marriages. And let's say that one of the spouses says, I want my interest upon my passing to go to my kids. And the other spouse says, great, well, I want my interest to go to my kids. If that's the case, the community property, the pure community property designation is going to likely be the best for that person. But we also have community property with right of survivorship. Now, this is probably the most commonly way a married couple will take title in Arizona. Community property with the right of survivorship means that upon my passing, my interest automatically goes to my wife, the surviving spouse. We don't
Okay.
need to look at these other interests that may be had once someone passes away. It automatically goes to the spouse. So that's a little bit of a distinction that a lot of people don't understand. And when you get this big packet of title documents and you're a married couple, you don't know, hey, do I want it to go to you? There's no sort of real explanation as to how that really works. So for the majority of married couples, you're going to want to have the designation with the right of survivorship. That's just kind of traditionally what people do in those circumstances. But if you've got a situation in which you want your interest to go to someone other than the surviving spouse, community property with right of survivorship is not the correct designation, and you don't want that. So that's one of the quirks we have here in Arizona because we are a community property state. Everything is presumed to be a community asset, and therefore, you basically have two designations that you can choose from.
Okay, and I'm just going to tie into some of our previous segments and just ask a couple of quick questions. So the right of survivorship with the community property designation, when you pass away, your interest goes to the surviving spouse in that case. That reminds me of kind of the disclaimer deed, right? Where I assume that, and I should ask, but I assume that means that it avoids probate through that right of survivorship because it's already built into the document to just transfer.
It is kind of analogous to the beneficiary deed. There's a couple of key distinctions. You wouldn't usually put a spouse on a beneficiary deed, whereas you would in the community property with right of survivorship. Your point about the probate avoidance, though, is well taken because automatically it goes to that surviving spouse, just like in a beneficiary deed, it automatically goes to that beneficiary without the need for probate. Yes, that is 100%
Okay.
correct. Now, the issue then becomes, what if both spouses pass? Then what do we do? Because the survivorships are gone. And then we, you get into some other estate planning tools, et cetera. But yeah, you're exactly right. That sort of automatic, no need for probate, that's a huge benefit of the community property with right of survivorship. Anything with the right of survivorship is usually going to be beneficial as well. Now, I'll tell you one thing. There's also an interesting distinction in connection with the beneficiary deed versus the title as community property with right of survivorship. With the beneficiary deed, up until my death, I can change my beneficiary. With the community property
Ah,
with survivorship,
sure.
I can't change it because unless I get a divorce. So
Gotcha.
yeah,
Okay.
so that's so the only real way to break the community property with right of survivorship is through divorce.
That's interesting. Okay, great. Yeah. No, I like the differentiation. And for those of you that have missed it, please pop back and look at some of the other segments as we did, dive into the estate planning side of the world, because a lot of this will tie together. Even though this is really kind of designed to be encapsulated as to the title stuff, but some of the concepts are going to be crossed over from some of the previous conversations that we've had. So one that I've seen, and I've seen this in many states that I'm licensed in, when we talk about title, is sort of I don't almost want to call it like the more generic vanilla type of titles, like tenancy in common. So can you help us understand that one?
Absolutely. So tenancy in common is the sort of generic designation. It sort of is the percentage interest or fractional interest in a property way of holding title. And so when you have a tenancy in common, each sort of co-tenant, each owner has a sort of common interest in the whole. They can access the entire thing, but they really only have a percentage interest in the overall ownership of the property. Each tenant, it's kind of weird to call them tenants because people, think of the landlord tenant, but we're talking about very, very ancient law here. That each co-tenant has a proportionate share, and they can actually convey their share to someone else at any time. Okay, unless there's some sort of written agreement that says you can't do that. The default is you can convey it, you can sell your interest, you can encumber your percentage interest at any time. Okay. What that also means, though, is because I've got this fractional interest, it doesn't automatically pass to somebody upon my death. And so you
Hmm.
may have to probate that interest because it doesn't come with a survivorship interest. So again, each of these mechanisms to hold title is very, very unique, has different features. And so the tenancy in common is the one that we usually see when we're dealing with, unrelated parties. Sometimes boyfriend, girlfriend, will see investors, that type of stuff, where
Okay.
you want to keep these things separate. Like, let's say, Carl, yeah, you're my buddy here, but I don't want you to have my interest upon my passing. I want it to go to my kids, or I want it to go to my spouse, etc. And so if we have an investment together, we're going to be tenants in common, because it just wouldn't make sense for me to have a right of survivorship in your favor unless we had some other arrangement that, et cetera. But so it typically seen when it's buddies getting into an investment, when it's investors getting into an investment, et cetera. So it is a unique unique way of holding title.
And so if I understand it right, then the other side of that coin could be, you and I invest, in some kind of investment property, and we're holding it by tenancy in common, and then you find a better deal elsewhere, and you could literally sell your interest, and I could then end up with a new partner, essentially.
Yeah, you could. Now, what we recommend is that people have what's called a tenancy in common agreement, or something that addresses that exact scenario.
Okay.
Because let's say I want to sell my interest, you may want to have some say in who you're co-owning this property with. You may want some sort of guarantee from them that they're going to comply with the tenancy in common agreement, or they're going to make the payments, et cetera. And so you're absolutely right that if we didn't have a default provision, if we didn't have this document that outlines who's doing what and when, or what transfers, like you just mentioned, are prohibited or permitted, then you definitely want what's called a tenancy in common agreement or co-tenancy agreement or something to that effect that we have between each other to address a situation where I want out and you want to bring in some other person to manage the investment or to handle the investment. So it's imperative in those situations that if we are co-tenants, particularly if it's an investment project, that we have that separate document outlining exactly how we're going to treat this sort of quasi business.
And without getting too deep in the weeds, I mean, I assume that, at a deeper level, we're talking about, okay, we'd probably have an LLC and we'd have an operating agreement in place, right?
Exactly. And so, yeah, so each of us could actually hold, we could share the property as tenants in common, but each of those tenants, the owners, could be our own separate LLCs, which would protect us from each other and protect us possibly from third-party claims as well. So yeah, so sometimes we see these big LLC arrangements and we have an operating agreement, et cetera. And I think that's a great idea, particularly if this is a true investment property.
That makes a lot of sense. And I guess just like sort of the follow-up question on that, I have real estate partners um, uh, in deals. You know, I guess my question is like, if you're holding it by tenancy in the common and one of those partners passes away, right? Assuming that, because there is no right of survivorship, right? So that share would not fall and roll over to me. It would go to presumably their heirs, and you would then potentially wind up with a partner for, a different reason. Is that a fair statement?
100%. So
Okay.
that interest would likely have to be probated, and then it would go to an heir or whatever. And ultimately, you may be stuck with somebody else you don't like or don't want to have there. And so,
Or
right,
doesn't understand the investment or has never had an investment property per se before.
100%. And so that is why, again, that tenancy in common agreement among the partners, among the owners, is imperative, because what you may want to do in that situation is say, okay, look, so and so passed away, so and so had a 1/5 interest in the property. We have the right to automatically purchase that 1/5 interest from the estate once that gets resolved, and therefore we won't have somebody we don't know involved here. So yeah, that's why that document is incredibly important if you're considering doing a tenancy in common agreement with co-business partners.
Yeah, that's great. Thank you. It's always great to see like, who you would recommend that style of, holding title for, right? And why. Um,
But it's exactly, and it's an option, right? And
right.
so, but look, if you wanted somebody to have the right of survivorship and you didn't include that in there, and it's going to default to the tenancy in common situation. Yikes. That's where we see some of these goof ups, or we also see the goof ups in people preparing their own tenancy in common agreement and cutting and pasting from the internet or wherever they get this information, and then that really affects, now we're stuck with so and so partner, or no, now we've
Right.
allowed this sale to happen and we didn't have any input in it. So it's imperative that you get some cleaned up stuff and you're doing exactly what it is you really want here.
Well, before we jump into the next ones, I guess that's a great segue to just talk about it's not one size fits all. There might be 4, 5, 6 options from, a title company on a piece of paper that says, how would you like to hold title? This is a great time to measure twice and cut once. And when you have a question, reach out to Patrick and his team to get the advice, because undoing it is also costly. And even if it's not, an imperative situation dealing with death, if you just make a wrong decision, I've seen, and I'm sure you can go into detail, where people have tried to fix title issues through new deeds that have been recorded, and oftentimes those are not handled through a title company, right? They're a third-party service or self-service where people just grab stuff from the internet and start cutting and pasting. So, in a minute, maybe you can talk to us about the ways to, repair or modify, or if there's been a change of circumstances, change the actual deeds and who holds title. Um, but before that, I wanted to jump back to the last one that I see a lot, is joint tenancy with rights to survivorship.
Yep, that's another option in Arizona. Joint tenancy with right of survivorship, very similar to that community property with right of survivorship that we talked about. The only difference here is that the couple or the owners are not married, right? So sometimes you see boyfriend, girlfriend doing this, boyfriend, boyfriend, girlfriend, girlfriend. Business partners that may want to have the right of survivorship just because they've made that arrangement. And
Mhm.
so in this situation, you can't be married. Well, I suppose you could be married, but typically the parties don't need to be married, right? So the to get the designation of community property, whichever one you choose, you have to be married. In this one, you don't have to be married. So you and I could do a right of survivorship. You and I could do a joint tenancy with right of survivorship, Carl, if we wanted to. We
Okay.
would each have our own interest, undivided interest in the property. We could each use the entire property. And so we would both have to sign in any sort of conveyance or in any sort of mortgage that we would put on the property, that we both have to sign that and have permission to do that. Now, the big difference here is, let's say that you and I have a falling out. We have this joint tenancy with right of survivorship, and you say, I want out of this property, it's a money pit, whatever. And I say, no, 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 we're keeping it. This is a great deal. Let's keep hanging on to this. Ultimately, if we can't resolve our differences, we have to do, or what will ultimately happen is one of us will file for partition. Okay. A partition action is a lawsuit that basically says, Judge, because we can't split this property in half, because we can't just saw this home in half, we need an order of partition, in which case the property will be sold, and we will both obtain our proceeds that way. So I may not even want that to happen. I want to
Right.
keep the property. I like the investment. I like the house. Maybe I'm staying in there. But you don't, and you say, we got to sell this, and you can actually force that to happen. Now, I have the right to buy it through the partition action, but I really don't have much of a defense if you want to do that. And so that's the sort of remedy that people have if they want out of that investment, if they want out of that property, when the other party doesn't. In the community property situation, it's not called a partition, it's called a divorce. So we can
Yeah,
kind of
I've
see,
heard of that. I've heard
yeah.
of that.
So all of it, yeah, exactly. So all of these things, you can see how they now work together. So we're condensing a lot of law stuff into, oh, okay, well, it's actually not that big of a deal. It all works together. It's all sort of cyclical, right? And so yeah, so
All right, so
the
let me see if I understand that right. So if you did the joint tenancy with rights to survivorship, one of the potential benefits for the non-married people would be, um, upon the passing of one, their interest rolls to the other person, or parties in case there's more. I don't know if joint tenancy, if you can have 3 or 4 people on there, um, or not, with the rights to survivorship, but your interest rolls to the other party automatically upon your death. Again, avoiding probate at that point because that's written into the deed. But the downside could be, yeah, if I understand it right, that if one party wants out for whatever reason and they can't come to an agreement, it would essentially be a forced sale, whether the other parties like it or not.
exactly,
That's a
exactly.
big deal.
So
That's
it
a
is
big
a big
deal.
deal. It is a big deal. And so in some of those instances, we again recommend that if let's say it's boyfriend, girlfriend, hey, we want to buy our first property together. And it's going to be great because then we're eventually going to get married and we can retitle the property at
Mhm.
afterwards once we get married. But for now, we're going to have joint tenancy with right of survivorship. It's imperative in that situation that you again have this sort of side separate agreement, just like we had in the tenants in common situation, that says, okay, if one of us wants out, if we break up, etc., then here's what we're going to do to resolve this dispute so that we don't have to go to a partition. So you're agreeing to this stuff ahead of time, instead of just kind of winging it. Because when you just wing it, you create a mess, and you're at
Mhm.
the whim of the court system, etc. And so those things can go sideways when it goes to court. And so if you have an agreement that says, okay, look, what happens if we break up? I mean, I've seen that happen many
Mhm.
times, and
Me
that is,
too.
yeah, the most common partition situation is, the boyfriend and girlfriend, um and they break up, and they didn't have a separate agreement addressing who gets what when, if they're not married at the time of the breakup.
Yeah, you're right, and I've seen that over the years many times. Even with siblings purchasing a home, parents co-signing for their children, things change, things evolve, and I can't agree more that those what if scenarios need to be written down on paper and should be bounced off uh, someone like you, because nothing also tears up a family worse than these kind of disagreements. And we're not even to the discussion of dying and passing away. We're just talking about disagreements while alive. And I've seen that rip families apart, and the forced sale aspects of things like this is just horrible.
Well, yeah, let's say you have a husband and wife who reside in a property, and then you have a wife who has better credit, but may need a cosigner with their mom, right? And so now you've
Mhm.
got the title, or the mortgage company is going to say, well, she needs to be on title, right? We
Correct.
want her to be on title. She needs to be an owner. So ultimately, daughter and mom now own this property as joint tenants with right of survivorship. Well, what can husband do, and what can husband say here? What happens if mom wants to sort of sell the property? She wants off the loan. She wants all sort. I mean, these types of things can create some title problems, some legal problems for sure. So again, knowing ahead of time what could happen, and how you're going to deal with it, and documenting that is usually the best course. But most people just don't go there because it's family. We're gonna be fine. Everything will be fine. Well, we all get along. We all agree on everything. But
Yeah, I've seen a lot of situations where, someone is co-signing for someone else, and we set up kind of a plan on the front side, and the idea is, in 18 months or in 24 months, they'll refinance and take the co-signer off the loan, and that's all great until it isn't. And these are the things that to have it in writing as to what happens when and if and how, I think are super critical. Now, let's say that you have a situation like the boyfriend girlfriend um, purchase a home together, and they're holding it, let's say, as tenants in common, and they get married. What is sort of the procedure, and how would they want to then say, okay, well, dang, now we have a community, right? Do we want to redeed this, and should we do this ourselves and just go to a website or Google? And what does Arizona kind of say about the deeds themselves as how they want things?
yeah, so in that situation, assuming that the couple wanted to put this as a community asset, it would ultimately be a community asset at some point, anyways. I think. But ultimately, all you have to do is a deed from the couple as tenants in common to the couple as community property with right of survivorship. So it
Okay.
is just a deed. Now, when a person goes and records a deed, let's say we're in Maricopa County, or frankly any county in the state or the county is not looking at what you've done. they will accept your recording. They will accept your recorded document, irrespective of what's in it, right? And so they're not going to check it for correctness. They're not going to go through this step by step as to did you even get the right property address, that sort of stuff. So you can go and record something. I mean, frankly, you could record a conveyance of the Grand Canyon to yourself. The county recorder isn't going to do anything about it. It's going to sit in the county records, believe it or not. So again, you may want to have an extra eye on that deed before you record it, because once it's recorded, you're putting third parties on notice. This is how it is. And so it's probably a good idea. Now, what a lot of people do as well is they'll say, oh, okay, well, all you have to do is quit claim the property to us in our different capacity. From a strictly legal perspective, that works, right? But from a title company perspective, and the title company is really who we have to satisfy here, because they're the one issuing a title insurance policy. A quitclaim deed usually isn't going to get it done. A quitclaim deed has fallen out of disfavor with title companies, even though, again, under Arizona law, they're fine. You got to use a warranty deed. So to me, if a couple wanted to change from tenants in common, this is a long-winded way of me saying if they wanted to do that, number one, they should use a warranty deed. Number two, they should probably have at least, someone glance over this and ensure that they've got the right property address, that they've got the right legal description for the property, and that this is the way in which they truly want to hold that interest, and then go and record that, as opposed to cutting and pasting from the internet, from Google, from whatever. Yes, there's some great information out there. There's some great forms out there, but I can tell you this, anytime somebody starts using Google and the other AI and anything else out there, those are the most litigated agreements in my office, and I suspect in many other real estate law offices around the country. And so the sort of saying goes, ounce of prevention, pound of cure kind of a thing. It's not a bad idea, even though it's just a deed, right? It's something, anybody can do it, right? It's probably a good idea to have somebody take a quick glance at it.
I agree. And while I think that's exactly what people would say is it's just a deed. And it's like, yeah, it's just the ownership claim on the property. Like it doesn't get any more important in my eyes than that. I mean, the loan is the loan, right? Whoever is responsible for making a mortgage payment is on the hook with the lender, and the servicing company. But who cares who has to make the payment on the Ferrari? I'd rather have the title, right? I want to have the ownership claim. So it is important, right? That we get that right, and that people know that there's a difference, and sometimes things change, but they need to be addressed, and it's worth a little time and effort to just look over your shoulder and make sure you're doing it correctly. Because who wants to do it twice, right? The second go around, as we'll probably talk about in a second, when things go poorly is stressful, time consuming, and often expensive. So now might be a really good time for just a real quick break, and we'll jump into to the wrap up and a couple of quick comments here in a second. So stand by one sec.